After 6, we'll hear from the CTV chairman, who tells us he believed the building was robust and safe, and it had been checked after the September earthquake. We'll hear from Kendall Lamont, who was with her 2 young children on the 5th floor of the building when it collapsed beneath them. All 3 of them survived. And we'll hear from Tim Elms, who lost a daughter and who'd worked as an electrician, and compares the supervision and scrutiny he was under in his professional life with the lack of it in the CTV building. That's after 6. But the lawyer, Nigel Hampton, acted as family counsel before the Royal Commission. A Christchurch-based QC, of course, he knows the case forensically well. I asked him about the decision to not prosecute.
I find it extraordinary to, on the one hand, have a document that says that a senior prosecutor, the Canterbury Crown Solicitor, thought that the evidential sufficiency test was met, yet somehow the public interest test does not seem to be factored into the decision made by the Deputy Solicitor General and the police not to take a prosecution. Why take a so-called conservative approach when, if they are correct in the view that there were significant design deficiencies in this building in which 115 people die, surely the public interest is in a prosecution being taken. But certainly the public interest should be taken into account in making a decision as to whether to prosecute or not. It doesn't seem to have been.
Is this decision wrong? Is the decision to not prosecute wrong?
Look, if evidential sufficiency test was met, then surely the second leg of the prosecutor's guidelines test, that is of public interest, would require a prosecution to be taken where 115 people have died. And I use the word require because public interest must surely be in at least attempting to hold in the person or people thought to be responsible to account in a public court of law. Put them on trial, let it go to trial, let the judge or the jury, probably the jury, determine if the evidence does make out a case. But surely the public interest, where there have been 115 deaths, where there is an evidential sufficiency, is in favour of an approach of prosecution. It is not in favour of a timid, conservative approach saying, no, we don't want to touch this. I think it is a woeful decision.
A woeful decision. Nigel Hampton, QC.